We had a landmark decision in the High Court of Australia yesterday about whether an Indigenous person could ever be considered an alien. Joining us live for more on this is Pauline Wright, President of the Law Council. Pauline, thank you for your time.
That's a pleasure.
It was a split decision. It was very close. Was it what you expected?
Well, yes, it's a natural flow on from the Mabo No. 2 decision, really, that talks about inalienable rights and land title.
What Mabo does talk about, though, is having that ongoing connection with the land to be able to be considered. I know that's to be a traditional owner, but that ongoing connection. So when you're talking about two people who've been born overseas, this is quite an interesting decision.
Well, in a sense, Aboriginal people have an ongoing special connection with the land that is their country. And that was recognised by the High Court in this decision, that they've got a special traditional role. And that connection is inalienable, and they can't be ever considered an alien from the country that they're Indigenous to.
It's interesting though, because you create, do you not, sort of an elevated right for Indigenous Australians over anyone else, even someone born in the country versus someone not born in the country. It's unusual in that sense, in the least, isn't it?
I'm not sure that it's an elevated right. It's just a special right because no one else in Australia, no other Australians are Indigenous to the land. So it's just that special connection that they have.
One of the interesting things that the case is also examining is what it means to be Indigenous, because one of those parties, there still hasn't been a definitive decision on whether he is actually Indigenous. Do you think that's going to further complicate that discussion?
I think that's right. The person has to be recognised as being an Aboriginal person or a Torres Strait Islander person by members of their community. That's part of the assessment, and if they are found to be accepted by that community, then they'll be accepted as Aboriginal or Torres Strait Islander people.
Any other potential flow-ons, whether it be Indigenous people, I don't know, having to fill in a card on the way into immigration? How much could this flow through other parts of immigration law?
Look, I think it's going to be a principle that will apply across the board. You just can't, the government has no power to...
What are some examples of how it could apply though?
Well, you simply can't treat an Aboriginal person ever as being alien from Australia because they're Indigenous to the land. So whatever decision might be made. And
beyond just immigration laws then?
Yes.
Because there is the ability for Parliament, obviously, to make laws for Indigenous people. How does that marry up with this decision?
It's perfectly comfortable. Laws can be made for Aboriginal people, but you can't make them alienated from their Indigenous heritage and their country.
It is an interesting discussion when you say about whether they should be accepted, whether they need to be accepted by their community to be considered Indigenous. And you're talking about two people who've been born overseas. Surely if there is that kind of stretch of time, that lack of connection with their community, that would be a very hard hurdle to clear.
Not necessarily. If you've got someone who happened to be born overseas, their parents might be on holidays. They're born overseas, they come back to Australia and they grow up in Australia.
But this wasn't the case here.
In one case it was, in the other case it wasn't. It wasn't holidays, but
short amount of time.
Take the point, short amount of time. And the other one was a couple of generations back. So they're different circumstances, but you just have to show that connection with the Aboriginal community and that you have been accepted by them as being an Aboriginal person.
Also, reports today of this committee going about trying to get the Indigenous voice to Parliament, that they're being encouraged, shall we say, or insisted upon not talking to the media. What do you make of this process?
Look, it's, as I understand it, they're being encouraged not to talk about constitutional recognition in their discussions as a panel. That's my understanding of it. I think that they should have the freedom to speak about whatever recommendations that they want to make. They ought not to be hampered about what they can or can't talk about. I think that if they're going to make a sensible decision, they need to be able to consider all factors.
Because it does seem rather undemocratic to not allow discussion on a certain topic, and especially not being allowed to talk to the media. You're happy to front up and make your case. Why shouldn't they be allowed to do the same?
That's my view. I think that they should be allowed to speak about whatever they wish to freely.